This is 10 minutes of dictation at 200 words per minute. People is Mr. Jones, defense is Mr. Gould. Here's the glossary. Honor Farm, Greg Bloom, Randy Kirkpatrick, Mr. Smith, Lake Berryessa, Teresa, Distrel, Armstrong Kitchens.
Plaintiff's attorney is Mr. Jones.
The witness.
Court.
I'm defense counsel Mr. Gould.
For the record, what did I tell you relative to what I might do to protect your safety while you were at the Honor Farm?
You did say you would call the sheriff in charge and request that he keep an eye, or I was to inform him if I had any problems there.
And did I also tell you that if I could not ensure your safety at the Honor Farm, I would make sure...
Excuse me, could we please have Mr. Jones stop testifying unless he takes the oath?
It's pretty hard to extricate this kind of testimony without suggesting what the statement was. The witness is free to...
Well, I would certainly have no objection to a narrative question. Why don't you ask the witness what was said?
The objection in this instance is overruled.
Thank you.
The question again, please.
I don't think I got a chance to finish. Let me try it again. Can you tell the jury whether or not I told you anything to the effect that if I could not...
That's a leading question.
See, there you go. When you say whether or not, it could go either way. Tell me whether or not the sky was blue that day. Could have been raining, so whether or not is a little different than the sky was blue. So that's a satisfactory question. It's not leading.
Well, Your Honor, I'd like to object also on the grounds the whether or not he's posing has only one possible answer.
I don't know. I've never heard the testimony, so I'll have to wait and see, and so will you. Your objection is overruled.
Can you tell the jury whether or not I said anything to you to the effect that if I cannot ensure your safety at the Honor Farm, I would see that you were removed from the Honor Farm?
Yes, you did.
Now, let me ask you about the first assurance that I gave you that I would...
Your Honor, if this isn't leading, it's certainly suggestive.
Why don't you wait to hear the whole question? Some questions can be rescued from their suggestive character, others not. We can't be sure yet because we haven't heard the question.
But Mr. Jones has already told us that this is a first assurance. There is no way for anyone to tell whether or not this witness can remember anything.
Stand at the ready, Mr. Gould, with your objection as soon as he gets the question out. Because until I have the question, I have no means of making an analysis of the objection.
All right.
Be ready now.
Now, relative to the topic of providing the fact of your cooperation to the sentencing court in the conviction for contempt, what did that conviction stem from?
Refusing to testify.
At what case?
Bloom and Kirkpatrick.
And approximately when was that trial that you refused to testify at?
Approximately 10 months ago, year ago.
And in the course of those proceedings, can you tell the jury whether or not at that time you were provided immunity?
Yes, I was.
And can you tell the jury whether or not the immunity that you were provided there was of the same scope of the immunity that you were provided in these proceedings?
Yes.
Move to strike the answer because I believe that calls for a legal opinion.
Overruled.
I think it's beyond the witness's competency to say whether it was use or transactional immunity.
Well, you can question him on that. Overruled.
It's the exact same language, isn't it, Mr. Smith?
Yes.
When you refused to testify at this previous trial after the granting of immunity, what happened to you?
At that point, I was sent to dorm 4 of the farm.
Then you were, what's dorm 4?
Taken to jail.
And how long did you stay in jail?
13 days.
Were you told if there was anything that you could do to get out of jail?
I was told to get out of jail, I'd have to testify.
At the time that you were released after serving 13 days, are you aware of whether or not the trial was still in progress?
No, the trial was over.
And how do you know that?
My attorney, he filed a motion to release me at the end of the trial.
And after you were released, did you have occasion to see the two defendants in this case, Mr. Bloom and Mr. Kirkpatrick?
I seen them on an occasion or two, yes.
I'm sorry, Your Honor.
He said he has seen them on an occasion or two.
When was the first time that you saw the two of them after you were released?
Ambiguous as to whether it includes both or either or some or all.
I mean, well, let's make it either.
I saw both of them it was either Greg or Randy's attorney's office after I was released from jail before the verdict, I believe.
And was it your understanding, can you tell the jury whether or not it was your understanding that the jury was deliberating at that time?
Excuse me, Your Honor. Move to strike. That obviously calls for hearsay.
Beyond your knowledge, sustained.
Could the jury be advised?
The answer should not be regarded.
Thank you.
How long did you stay at the attorney's office at that time?
Maybe 5 minutes.
Can you explain to the jury why you have agreed to testify in this matter at this time?
Excuse me, Your Honor, I believe that's not relevant.
Oh, I think it is. I think it is. Overruled.
To keep from further prosecution.
And what is your understanding of what that position could entail?
I'm on probation now for 3 years. I'm facing 6 months for the first contempt of court. I can do...
I'm sorry. Could you suggest to Mr. Smith that he pick his voice up a little and that he speak a little more slowly?
Take a deep breath. Get some volume in your voice.
I'm on probation now. I'm still facing contempt of court from the first time. I'm facing 6 months on that. Since I'm on probation, I would commit a crime if I didn't testify. I could go to jail up to 3 years for a probation violation, plus contempt of court charges again.
Now, in exchange for the assurance that I gave you, what, if anything, did I ask in return?
I tell the truth.
Your Honor, I'm going to object. That's hearsay. I don't see how it has anything to do with his state of mind.
Overruled. It's the use, any use which you can make of the statement by Mr. Jones revealed to you through the testimony of this witness is limited, as I mentioned, and not to be used otherwise. All right.
Could I have that answer read back then, Your Honor?
Did I say anything to you as to whether or not any benefit you would receive would be affected by whether these two men or either of them are found guilty or found innocent?
My outcome remains the same.
And did I tell you that?
Yes.
Let's back up a little bit.
Excuse me, just for clarity. I'm sorry, Mr. Jones. Are we talking about the conversation of February the 6th?
Yes.
Thank you.
You are acquainted with the defendant in this case, Greg Bloom?
Yes.
Can you tell the jury when you came to be acquainted with Greg Bloom?
I met him approximately 10 years ago or more at Lake Berryessa.
Under what circumstances?
Water skiing weekend. I met him through his girlfriend, Teresa.
What kind of skiing?
Water skiing.
Do you know her last name?
Distral.
And after you were first introduced to Greg Bloom approximately 10 years ago, did the relationship with him develop from there?
Yes, it did.
Would you describe that for the jury?
We went out together weekends a lot. After several years, he began working for the same company I worked for, Armstrong Kitchens. Our friendship increased.
In what capacity were you employed by Armstrong Kitchens?
I was the foreman there. It was a family company.
Doing what?
I was a kitchen designer.
And what kind of income did you have as a kitchen designer?
Oh, approximately $60,000 a year.
At some point during your relationship with Greg Bloom, did you begin using narcotics with him?
Yes.
What kind of drugs did you start using with him?
Cocaine, marijuana occasionally.
Approximately how long ago was that?
Approximately 4 years ago or so.
At some point in the course of your relationship with Greg Bloom, did you come to form an opinion as to whether or not he was involved in cocaine trafficking?
Yes.
Approximately when was it that you formed this opinion?
Your Honor, I'm going to object to his opinion, whether he is involved.
I don't think he's been asked for his opinion, but when he formed one.
That's correct. What is the relevance of that?
It may affect his testimony, so overrule your objection.
Yes, I'd say approximately...
Excuse me, I think the witness has answered the question, has he not, Your Honor?
No, I think it was a time. The question was what time he developed it.
I'm sorry.
I'd say approximately 6 months before my arrest.
What, if anything, occurred to cause you to form this opinion?
I bought a small amount of cocaine from him at a very good price.
At a what?
At a very good price.
Again, you're going to have to try to keep your voice up. How much cocaine did you purchase?
It wasn't weighed, approximately a couple of grams.
And how much did you pay for these couple grams?
I believe around $30 or $40.
Had you been buying cocaine around that time in the open market?
Yes.
And were you familiar, based upon your purchase of cocaine, what the going price was for a gram of cocaine at that time?
Yes, I was.
And what was the approximate cost of a gram of cocaine at that time?
$100.
At some point after you made this purchase of a couple of grams from Mr. Bloom, did you become involved in any drug trafficking with him?
Yes, I did.
Approximately how long after that transaction?
Couple months, month or two.
And could you tell me how that came about?
I believe it started out I was buying larger quantities to sell to get me high.
Excuse me, Your Honor. I'm going to object to the answer and move to strike it. The witness stated a belief as opposed to a fact or recollection.
The answer should go out. Why don't you restate the question?
It's a narrative. I'd object to him giving a narrative response.
Well, he didn't get enough out to know whether it's a narrative. We will start over on that question.
May I ask the court to advise the jury at this time? I don't think it will be necessary every time that when something is stricken what they're supposed to do.
Striking an answer means that it's taken out of the case entirely. You should treat it as though you never heard it. That's what we do when we strike things. If something is stricken after an objection is made, you mustn't consider it. All right, do you want to start that question again?
And how was it that you became involved in narcotics transactions with Mr. Bloom?
I was buying larger quantities of cocaine to sell it. Not so much for a profit, but so I could get high without paying for it.